I run the joint.
Okay.
Okay, great. Well, let's get started. So, welcome. I want to welcome you on behalf of the Broad Institute and the Petrie-Flom Center. In a moment, I'll introduce our Dean, Martha Minow, who will be the moderator. I'm Glenn Cohen, but before we start, some thanks are in order. In particular, I want to thank on my staff, I want to thank Holly Lynch and Christine Hutchinson-Jones. And then I also want to thank Todd Carter on the Broad staff and really the people who work for him for really making this event come together. So with that said, let me introduce our Dean, Martha Minow, who has generously agreed to moderate this discussion.
What Glenn did not say is I've been begging for this discussion since this case first came on my mental map. So I am very, very excited that this is happening. And I welcome everyone to this event and thank Glenn as well for helping to organize it. We are being recorded. We are also being broadcast live. There's also an overflow room for others who want to be here, and those in that room, just rest assured, we will be collecting any questions that you may have when we open it up for questions and answers. So, are human genes patentable? There's several problems with that question. What is a gene? What is a human being? What is DNA? What is cDNA? What is a synthetic gene? And what is patentable? This panel will explore all of those issues in the context of this most recent Supreme Court decision, high profile, against a backdrop of a 1911 decision that says an inventor cannot patent a product of nature, but can patent a natural product that is isolated and purified, whatever that may mean. What does that all mean in the context of locating and sequencing gene variations? We will also consider the impact of the answer that the Supreme Court gave on sequencing, on research, on pricing of genetic testing, on pricing of medical care, on application to non-human genes, on naturally occurring proteins and molecules, even on application on the particular company's own data, Myriad's 8 years of data. Last term, the Supreme Court had some high-profile cases about same-sex marriage, affirmative action, voting rights, access to court, but I'll put my money on this one as the one with the longest enduring significance. But that actually is another question for this panel, which is how crucial is the decision? There are those who say it's a major victory for civil liberties, scientific freedom, for patients, for the future of personalized medicine. There are others who say it's not that important a case. The patents at issue were about to expire. Not much will change. So that's another question that I put on the table as we turn to this outstanding panel. We're going to start with Tanya Simoncelli, who served as the science advisor to the American Civil Liberties Union, and I have on good authority helped to instigate this case. She spearheaded the development of the litigation and guided the organization's responses to this and other science policy questions. She's going to give us the background of the case. We're then going to turn back to Glenn Cohen, who will tell us more about the prior case law, the legal setting in which the case arose. We will then have a mini debate discussion with two of the protagonists, shall we say. Eric Lander, one of the principal leaders of the Human Genome Project, which is the international project that determined and made freely available the DNA sequence of the human genome. And he's also the president and founding director of the Broad Institute, the biomedical research institute affiliated both with Harvard and MIT that is, shall I say, changing the world. In another life, he's also a professor of biology at MIT, but we actually like to claim him as a participant in Petrie-Flom activities forever. And then he will be in debate with Claire Laporte, graduate of this school, a trial attorney who represents life science clients in patent and technology-related matters. She wrote an amicus briefs in the Myriad case on behalf of the Federal Circuit Bar Association and advocated for the patentability of isolated DNA sequences. And then Ben Rowan, who is a Heiken Assistant Professor of Patent Law and Faculty Co-Director of the Petrie-Flom Center for Health Law, Policy, Biotechnology, and Bioethics, will comment and tell us what it all means. So, Tanya.
Look to you.
Thank you so much, and thanks to Eric and Glenn for inviting me to join this fabulous panel and discussion. I think my task, as was mentioned, is to sort of describe a little bit about the general background of this case and to provide some context for the debate that I'm sure will be very lively to follow. This case involved a legal challenge to patents on two genes, the BRCA1 and the BRCA2 genes. Myriad Genetics, a private company based in Utah, had applied and successfully obtained a series of patents on those genes beginning in the mid-1990s. Women with certain known mutations along the BRCA1 and BRCA2 genes are considered to be at a significantly increased risk of developing breast and ovarian cancer. And Myriad's patents, they actually contain hundreds of claims. And we challenged 15 of these claims, and the most controversial of these claims were claims to so-called isolated DNA corresponding to full-length genes, mutations along those genes, or fragments as short as 15 nucleotides. Isolated DNA meaning separated from the rest of the chromosome. So one reason for why those particular claims are so controversial is that virtually any conceivable use or application of a gene requires that it first be isolated. So patents on isolated DNA are in effect patents over the genes themselves. The impacts of these of patents on genes has been very well studied and established. Myriad itself has aggressively enforced its patents. For example, it sent out a series of cease and desist letters to labs that were offering BRCA testing at the time the patents were issued, and when asked, has refused to allow others to offer supplemental testing involving those genes. By maintaining its monopoly, Myriad has dictated the cost, the method, the quality, and the general standard of care in breast cancer predisposition testing for the past 15 years. This has had real impacts on patients, and I can't underscore that enough. Just to give one small example, in 2006, a study estimated that for several years, approximately 12% of high-risk women undergoing testing by Myriad received false negative test results because Myriad had failed to update its test to reflect additional known mutations that had been discovered by French researchers in France. Finally, they did update their test, but marketed it actually as a separate test at an additional cost and did not provide that test reflexively to all patients undergoing testing. Myriad, of course, is not the only entity that has patented genes, and this is important when we get to the implications of this case. It's estimated that patents have been issued on approximately 25% of human genes. A number of studies and other evidence have demonstrated that gene patents are not necessary for stimulating investment in gene discovery or ensuring the development of genetic tests, and instead they have actually served to inhibit research, data sharing, and innovation in diagnostic testing. These are all of the sort of broad policy reasons for why a very broad broad coalition of people came together to file this case. The case was filed in May of 2009. It was brought by the ACLU together with the Public Patent Foundation. We filed in the Southern District of New York on behalf of 20 plaintiffs, including 4 national scientific organizations whose members wanted to develop better, more comprehensive tests than the one provided by Myriad Genetics, clinical geneticists who had received, some of whom had received cease and desist letters from Myriad, genetic counselors who wished to provide their patients with more testing options, and individual women who couldn't access testing or wanted to obtain complementary testing. We were joined along the way by a number of amici, including some major organizational plaintiffs, such as the American Medical Association and the American Association of Human Genetics and the March of Dimes and others. There were many legal questions in this case, and I'm going to just focus on the one that was central to the Supreme Court and was sort of really the central legal question through and through, and that is isolated DNA a patent-eligible invention under Section 101 of the Patent Act? And I suspect you're going to hear a lot in the next presentations about Section 101 and the product of nature doctrine and the various arguments presented on either side, so I'm just going to cut to the chase and tell you that as the case made its way through the courts, there were some fascinating twists and turns. And in the end, the Supreme Court answered this question with the resounding no. The court unanimously held that a naturally occurring DNA segment is a product of nature and not patent eligible merely because it has been isolated. Furthermore, it found that Myriad did not create anything. To be sure, it found an important and useful gene, but separating that gene from its surrounding genetic material is not an act of invention. The court did find that cDNA, complementary DNA, is patent eligible because it is not naturally occurring. This is a more peripheral issue in the case because unlike the situation with genomic DNA, it is possible to invent around cDNA in designing new diagnostic tests. We can get into the details of this if people are interested, but the main question was really the question over genomic DNA. Just one couple of words on the impact of the decision. This was a tremendous victory, not only for our plaintiffs, but more generally for patients, for the future of biomedical research, and for personalized medicine. And it's a victory that I think few would have predicted when we started developing this case 7 years ago. After all, the PTO had been granting patents on, issuing patents on genes for more than 20 years. The biotech industry had grown up around this practice, and even though most biotech companies did not really depend on gene patents as part of their business models the way that Myriad did, it was still sort of part of the culture, if you will. And several attempts to oppose gene patents as a matter of policy over the last 20 or so years have failed. So why did we win? I think there are a lot of really, really fascinating sort of questions to probe as to how we ultimately prevailed in this case. There were a couple of very important events that occurred, but I think really the reason we prevailed is because we were right as a matter of policy and law, but also because we had an extraordinary and very broad coalition of very committed individuals and organizations involved in this case. There was one very important event, which is that when the case was before the federal circuit, the US government submitted a brief that was technically in support of neither party, but was fundamentally in support of the plaintiffs in the case. And in submitting that brief, the Solicitor General, in arguing before the court, at the oral argument made clear that the US government could no longer support the PTO's policy in issuing patents on genes. Oh, it's the US Patent and Trademark Office, sorry about that. The impact of the Supreme Court's decision was also, it was actually almost immediate, and I think that's very unusual. Within 24 hours, 5 laboratories had announced that they would begin to offer BRCA testing, some of them at lower prices than Myriad's test, and some were going to offer more comprehensive testing. And of course, it's important to note that this decision goes far beyond Myriad, which was always the point of this lawsuit. It effectively puts an end to the Patent and Trademark Office's fundamentally misguided policy of patenting genes and invalidates all existing claims to naturally occurring isolated DNA sequences. And with that, I will pass the baton.
Great. Thank you very much. So Dr. Lander will talk a little bit about the amicus brief that we filed with Gideon Shore that we co-wrote that the Supreme Court discussed extensively during oral argument. But what I'm going to give you is a little bit like the complete works of Shakespeare abridged, in that this is going to be a whirlwind fun, I hope fun, tour of patent law relating to biotechnology and to gene patenting in particular over the last 100 years or so. So as the dean, in 5 minutes.
All in 5 minutes.
Exactly. I'll be juggling knives while I do it. So as the dean suggested, the case really began in 1911 when we had Park Davis, was the decision of Judge Learned Hand, not in the Supreme Court, but in the Southern District of New York, actually, in 1911. There you had a patent that was directed towards a highly purified form of concentrated adrenaline. Now, adrenaline, as you know, maybe I'm feeling some of it right now, is a naturally occurring hormone. And despite the fact that it occurs naturally, its function and structure was well known at the time. It had been used therapeutically. Hand upheld the patent. Why? Well, he said that the purified and concentrated form of adrenaline, separated as it was from the surrounding gland tissue, was different in kind, he said, from adrenaline naturally flowing through a person's or other mammal's body. And he wrote, the patentee in question, quote, was the first to make it available for any use by removing it from the other gland tissue in which it was found. And while it is, of course, possible logically to call this a purification of the principle, it became, for every practical purpose, a new thing commercially and therapeutically. So again, this is kind of prefiguring the real question. Is this about purification? Not patentable subject matter. And again, Section 101 is about the threshold. We have a bunch of other tests for patentability, but if you can't get over the threshold of being patentable subject matter, you can't get anywhere. He said, not a purification, a new thing, and devised this kind of line. Well, the Supreme Court kind of tilted at it a little bit and didn't make things better. In fact, it made things, I think, more muddied. The next significant Supreme Court case is in 48, the Funk Brothers case. Kind of fun to say, Funk Brothers, is a patent claim directed to a bacterial mixture. Each of the bacterial strains in the mixture was both naturally occurring and well known. So we had two strains that were naturally occurring and well known. But the specific strain mixture involved was neither naturally occurring nor well known. And this was a great mixture. It promoted growth in a wide variety of leguminous plants, so children everywhere could eat their vegetables better, right? And the Supreme Court said, per Justice Douglas, that the subject matter of the invention did not qualify for patent protection because the court said the useful qualities of the mixture themselves were, quote, work of nature, and of course not patentable, for patents cannot issue for the discovery of the phenomena of nature. That is, quote, discovery of the fact that a certain strain of each species of this bacteria can be mixed without harmful effect to the properties of either is a discovery of their qualities of non-inhibition. It is no more than the discovery of some of the handiwork of nature, and hence it is not patentable, unquote. Well, that would seem to have put a kibosh on a lot of the biotechnology patenting area if it was strictly applied. A lot of those discoveries exploit natural quality of bacteria, viruses, proteins, nucleic acids. And unlocking the secrets of these biological materials, if the Funk Brother rule was strictly applied, would merely be, quote, an application of a newly discovered natural principle. Well, fast forward to the 1970s, where biotechnology is really kind of getting off the ground in America. Scientists are filing more and more patent applications for biotechnologies. The PTO, as well as the courts, are struggling to decide whether these living organisms are patentable or not. There's also a lot of fear of genetic engineering in the air as a sociology matter. And the court takes a case called Diamond v. Chakrabarty, decided in 1980. There, the Supreme Court rules that the living, human-made microorganisms are patentable under a law stating that a patent could be awarded for any intervention that were, quote, new and useful process, machine manufacture or composition of matter, or any new and useful improvement thereof. And this is about a bacteria that is engineered by Mr. Chakrabarty, who I actually met on another panel like this, which was fascinating, to break down crude oil that was developed by him while he was a GE employee to treat oil spills. So basically, he takes this bacteria, he re-engineers it so it can eat all kinds of polymers, I think, and that allows it to basically help clean up oil spills. Well, again, in a 5-4 ruling, the Supreme Court decides in favor of Chakrabarty and the patentability of the bacterium, stating that while natural laws, physical phenomena, discovery of minerals, plants, abstract ideas such as mathematical formulas like E equals mc squared are not patentable, this was different. The bacterium in question was living, human-made microorganism, and it was patentable. A genetically engineered bacteria capable of breaking down crude oil was not a product of nature, the court said, and thus constituted a new and useful manufacture or composition of matter within the meaning of the statute. And again, there is this dialogue here about unforeseen technologies, really a strong sniff or whiff of deference to Congress. If Congress doesn't want us to do this, they can always correct things. It turns out Congress hardly ever amends the Patent Act, but the Supreme Court on that day had a moment of judicial deference, maybe faux judicial deference, to be able to say we're going to listen to Congress in this one. Congress, of course, will intervene. Okay. So Chakrabarty kind of fuels the biotechnology industry in the 1980s, right? And a lot of the growth we have in that sector can be traced to Chakrabarty. But there is a way in which Chakrabarty is a bit sui generis, right? We're talking here about a new microorganism genetically engineered. What about human genome? Well, the last case before we get to Myriad that's relevant for our discussion here is in 2013, this very year, the decision in Prometheus v. Mayo, maybe it was 2012 actually, which concerned a process for using the drug thioropine to treat autoimmune diseases. Specifically, it turns out different patients metabolize that drug differently, and what the patent holder determined was that correlations between metabolite levels and a particular patient's dose, if they were too high, they would risk harmful side effects. If they were too low, they were likely to be ineffective. And what this person came up with was a formula for saying this is your dose, right? It had an administering step. It told the doctor to administer the drug to his patient. It then had a determining step. It told the doctor to measure the resulting metabolite level in the patient's blood. And then it had what the Supreme Court calls, I think kind of cutely, a where-in step. And in the where-in step, you describe the metabolite concentration above which there is a likelihood of harmful side effects, and below which is likely to be ineffective. And that tells the doctor that the concentrations are above or below a threshold, and that tells the doctor increase or decrease, respectively, the drug dosage. So the question is, was this a patentable thing or not? The Supreme Court says the relationship is a consequence of the way in which the compounds are metabolized by the body, entirely natural processes. It is or it isn't metabolized that way. And so a patent that simply describes that relationship sets forth a natural law and thus was not patentable. With the question the Supreme Court was asked was, do the patent claims add enough to their statement of the correlation to allow the processes they describe to qualify as patent-eligible process that apply natural laws? The Supreme Court said, no, there's not enough being added here. Instead, and I quote the court here, the upshot is that the three steps simply tell the doctor to gather data from which they may draw an inference in the light of correlations. To put the matter more succinctly, the claim informs a relevant audience about certain laws of nature. Any additional steps consist of a well-understood, routine, conventional activity already engaged in by the scientific community, and those steps, when viewed as a whole, add nothing significant beyond the sum of their parts taken separately. For these reasons, we believe that the steps are not sufficient to transform unpatentable natural correlations into patentable applications of those regularity. Now, there was an argument that actually mirrors Myriad quite a bit in Prometheus about whether this would doom the diagnostic industry, right? And this question of slowing, right? The amici said the U.S. has become the leader in this field. It requires protection. Then there were experts on the other side, like the AMA, the American College of Medical Genetics, et cetera, who said that if claims to exclusive rights over the body's natural response to illness and medical treatment are permitted to stand, the result will be a vast thicket of exclusive rights over the use of critical scientific data, and that we must remain widely available if physicians are to provide sound medical care. So again, in some ways, emanating in small part, fractally, the dispute at the heart of patent law is this notion of whether we're going to have pro-innovation or anti-innovation effects by locking up this technology, right? And here the Supreme Court, Justice Breyer again writing, said, you know, patent protection is, after all, a two-edged sword. We want to do both. At the same time, the patents law's general rules must govern inventive activity in many different fields of human endeavor, with the result that the practical effects of rules that reflect a general effort to balance these considerations may differ from one field to another. And he said, in consequence, we should hesitate before departing from established general legal laws, lest a new protective rule that seems to suit the need of a one field produces unforeseen results in another. And once again, faux deference. We must recognize the role of Congress in crafting more finely tailored rules where necessary. Okay, so Prometheus is decided. The Supreme Court has Myriad in its docket. It sends it back, remands in light of reconsideration in light of Prometheus, and that sets the stage for what happens next.
Dr. Lander.
Wow. All right, so I'm a scientist. I have been working on human genetics for a long time, going back to the mid-1980s when I first got interested in what would eventually become the Human Genome Project. So I worked with thousands of colleagues around the world to generate the information from the human genome. I'll say proudly in Cambridge that a third of the entire Human Genome Project was done here in Cambridge, the largest of anywhere in the world. And it's a pretty good thing. We also knew, well, it's great to have all that information. Doctors can use it everywhere. You know, academics can use it. Companies can use it. But we were very aware during the Human Genome Project that we had competition. There was, in fact, a competing effort by a private company that swooped in at the very end of the Human Genome Project called Celera Genomics, run by a guy called Craig Venter, who had actually originally been part of the Human Genome Project and bailed to set up Celera at the end. So they wanted to be able to patent human genes. And in effect, we end up at the very end racing to get as much of the human genome freely available in the public domain so that anybody could use it. Why do we care so much? We cared so much because, in fact, information in science, and particularly in biomedicine, is cumulative. It isn't one piece of information you need. You have to mix and match combinations of information. You need not to look at one gene, but compare things across the whole genome. And if that was balkanized into separate preserves, you'd be in a lot of trouble. And you might have to cross-reference to the mouse genome and this genome. And so we envisaged a world where one would have to combine all of this information. So it was very concerning to us that people would go out and try to ring-fence pieces and say, thou shalt not use this piece of information. Now, I'm all for invention. I've helped found biotechnology companies. But if what you do is you say, I've made some clever invention, you have to go make some other invention, that's fine. But if you ring fence a piece of nature, you can't invent around it. I can't invent around your breast cancer gene because I actually have to look at it. There's no substitute for looking at the thing in the natural body. So this was a great concern to us. So we, of course, were concerned about this whole Myriad thing for a long time. And then, I guess in December of last year, I had occasion one night to pull the Federal Circuit decision that reversed the trial court, which had held the BRCA1 genes not to be patentable subject matter, and the Federal Circuit, which hears the patent cases and loves patents, it's never seen a patent it doesn't like. I don't mean that extremely, but of course, they're in the patent business. They like upholding patents. They, of course, reversed and upheld this patent. So I had occasion to read the decision, and I read the decision, and sort of a critical part of the decision was the whole human chromosomes, they're products of nature, obviously. But a piece of a human chromosome doesn't occur in nature. A piece of a human chromosome was obtained by clipping it out somehow, and pieces, not being products of nature, those can be inventions. So I read that about 11 o'clock at night, went to sleep, woke up the next morning, and attended a seminar at the Broad Institute given by a colleague on a genetic disease called Aicardi-Goutieres syndrome, which is a disease that affects how the body deals with random fragments of DNA that accumulate in cells. And there was this dissonance. I said, wait a second. Of course we know. We've known for 30 years that fragments of DNA, not just whole chromosomes, but fragments of DNA are perfectly products of nature too. You have all these mechanisms that create fragments of DNA. Why did the court say that they were not products of nature? And I went back and looked at the decision and found that the reason they gave was nothing whatsoever. There was no reference to facts below. There was no reference to any authorities. They just declared it ex cathedra. So I got kind of worked up about it, figuring that if the whole case was going to depend on a thing like that, well, maybe there ought to be an amicus that sort of pointed out that there was pretty clear scientific knowledge that fragments of DNA are quite natural, and that if this was legal fiction on which human genes were being patented, that legal fiction wasn't so good. You needed a better piece of fiction than that. So anyway, I then sought counsel to do that, found that almost all my friends at law firms were conflicted out because they had represented biotech firms, and eventually came to Glenn and to another colleague of his, and we filed. I filed on behalf of neither party because I did not fully agree with Myriad's position, certainly not with Myriad's position, but also not with the ACLU's position, in that I felt that this other kind of DNA, not the DNA in your chromosomes, but this other thing called cDNA, which is obtained, if this doesn't make any sense, don't worry about it, by taking RNA and copying it back into DNA, is not naturally occurring. And so I was in the middle, which ended up being the same position the Solicitor General took. Claire filed on behalf of the other position in this, and I will turn to her to briefly describe hers, and then we're going to discuss.
All right.
Counselor Laporte.
So I'll start out by saying I am not a scientist. So I feel some trepidation about the fact that I had the presumption to argue with Eric on this issue, but I did. So I have to account for it now. I represented the Federal Circuit Bar Association in filing an amicus brief in the case, and we are a bar association that works in the Federal Circuit, and as a result, a very large constituency of the Bar Association are companies that have patents of one kind and another, including biotechnology companies. So a very large number of biotechnology drugs, especially the older ones actually, are ones that are based on the use fundamentally of human genes. So they are based on trying to provide, through some kind of a drug infusion, often a gene product that the body is lacking. So we wanted to defend what had been happening in the patent office and what we regarded as an extremely important investment on the part of the biotechnology industry in these patents. And let me just say that the reach of these products that is based on the patents is very, very significant, all right? So ranging from practically every early drug that Genzyme made to human insulin, EPO, all kinds of drugs that are very, very important. Now, we can get into the details about cDNAs and full-length DNAs later and the extent to which that makes a difference. But just stepping back to the brief, Dr. Lander made the argument that there are these sort of loose fragments of DNA running around, and that meant that actually these isolated DNAs were something that was already found in nature. And I took some issue with that on the scientific basis that the fragments of DNA that occur naturally in the body tend to be little short ones that are not typically perfectly matched to the beginning and the end of a gene. And so that was sort of the technical scientific argument. So we also made a lot of other arguments about the importance of these patents and why the question that the Supreme Court was confronting was actually sort of nonsensical in a way, because there's nothing really about particular human genes that is distinctive. I mean, many DNA patents are not on human genes, but they're very important. They're not even necessarily on genes. They may be on other aspects of a genome, such as a regulatory DNA, that may have enormous importance. So we just tried to shed a little light on some of the implications of all of this, and so we did file a brief that supported the patentability of gene patents. So maybe then we should start on our debate here.
And of course, you and I both agree that there are incredibly important things in molecular biology that transform human health and deserve patent protection. We should say that the question is whether a human gene, that is, a sequence from within the human genome is patentable. Claire and I don't disagree on the question of whether or not, if you stitch together pieces of DNA, a human gene and a new control sequence and something else that haven't ever been together before, that new combination is clearly patent eligible. So we agree on that. There's this question here. So in the end, the Supreme Court ruled. What's wrong with it? Isn't it a happy situation now, or what's the problem?
Well, yes. I mean, I think that it is a fairly happy situation because the number of patents that are actually based on full-length genes rather than, okay, cDNAs. Are you going to explain this?
Sure.
All right. Well, anyway, so I think that the actual implications of the decision are slender, to say the least, because most of the use of genes in the biotechnology industry is use of so-called cDNAs, which are ones that you could say stitch together coding regions of DNA. Those are the ones that tend to be at issue most of the time, and so I think that the actual implications of the decision in areas other than, with regard to the Myriad patents, I think that the implications are small, actually, and I think that what happened was that the Supreme Court kind of went to the brink, realized that they really did not understand the technology and did not want to screw up the biotech industry, and made the narrowest ruling that they possibly could without seeming embarrassed. Frankly, that is what I think, especially when you read the Scalia opinion, where he says, I really have no idea what any of this means. I don't understand the technology, so I'll do what those people are saying is the right thing because, you know, there are 8 of them.
A truly stunning opinion there, saying, I concur in the result, but have no clue what it means. That is what the foundations of all this mean. It's an unusual decision,
You know,
opinion.
you could say that in a way he was more honest than the rest because based on the opinion as written, it's not clear to me that any of them actually understood it. And I
Oh,
do not
wait.
think that
They
baseball
did
bats or
understand
chocolate chip cookies are a valid analogy.
Wait. They completely understood the key point. And the key point is, if something already exists in the natural world, and we can come to this question of fragments or not, but basically what they're saying, which I think has big implications, is stuff that already exists in the natural world before the hand of man has come to it is the fodder for everybody's invention. And you can't claim it just by getting there first and extracting it, whether it's from a tree sap or from the human genome. You want a patent? Go invent something. Myriad went on and on in its brief saying how brilliant they were for having discovered this. But discovery, I think the Supreme Court sorted out very clearly, might win a Nobel Prize, but it wasn't an invention of a new thing. And Myriad's brief was basically a recitation of how hard it was and how important it was to discover this product of nature, the breast cancer gene. But, you know, Supreme Court said, great, but you didn't invent anything. And I think it's incredibly important because it defines the palette that everybody has available from which to paint.
Okay, well, so I would disagree with what you think the Supreme Court was holding, although I agree that it is very hard to tell. So what they say in the decision is that Myriad's claims are not saved by the fact that isolating DNA from the human genome severs chemical bonds and thereby creates a non-naturally occurring molecule, okay? So they're willing to accept, for purposes of argument, that something new was created. But they say that is not enough. And the reason is a little hard to tell, but what they say right after that part of the opinion is that the claims are not expressed in terms of chemical composition, nor do they rely on the chemical changes that result from the isolation. They're just all about the information in the DNA, okay? So to me, that is very troublesome when coupled with the part of the opinion that says Myriad did not create anything. Separating a gene from its surrounding genetic material is not an act of invention. So they're willing to say, okay, you did do something that was sort of technically new, but it's not enough. And they're departing from any kind of a bright line test, and I think getting us into a situation where they are muddying the standards for patent eligibility in Section 101 with questions of obviousness, which are a completely different question and one that has its own very complex and well-developed law.
So indeed, I have to agree with you here. What I offered to the Supreme Court in my amicus was a bright line test. Because in fact, fragments of DNA from the human genome actually occur. Infringing fragments under Myriad's patent, you have about 1 billion of them in your body right now, things that are items described in Myriad's patent. And I would have had a bright line test that said, if it is a product of nature, it's not patent eligible. But Justice Thomas adventurously goes further than I felt they even needed to go by saying, not just products of nature, but things that are not so different than products of nature, which I think will create an entire industry of patent lawyers trying to figure out what that means. Exactly how far do you go? Now, what they'd said here was that, well, look, it's pretty obvious that you care about the sequence of the nucleotides in the BRCA1 gene. And if you break it at its ends or break it anywhere in the middle, it doesn't much matter. The only thing you care about is its sequence. But I gotta agree, that's gonna be a tough thing to figure out exactly how that extends to other things. So if I isolate Taxol, an anti-cancer drug, from the bark of the yew tree, which is where it's found, is that patent eligible or not? Well, it got a patent. People sold it under this patent. But I think you'd have to say under Myriad, it now would not be patent eligible because it comes from the yew tree. But how about something that's kind of similar to Taxol? If I put a little group on it here or there, do I suddenly escape? Well, Justice Thomas has made a slightly bigger net here. What do we got?
Well, you remove a little piece from lysine and you get something that is sold as a drug.
Yeah.
So, I mean, you can make very minor alterations in something chemical and create very profound impacts. And so I'm troubled by the notion that you have to have some special sauce in what you've done when you are altering nature. So, for example, I think that the Supreme Court believes that they haven't in any way touched recombinant DNA.
Yes.
So, for example, if you isolate a human gene and you place it inside a circular DNA called a plasmid, I think that, and those plasmids come from bacteria, I think that the Supreme Court justices would think, well, that's very different because you've got bacterial DNA joined to human DNA. And so, of course, that's going to be fine. But really, under the logic of their opinion, it's not clear to me that it's so fine. And the reason for that is that the use of plasmids is trivial in biotechnology. They're used all the time, every single day. And so if you take a gene and you put that in a plasmid and you then write a claim that says this gene in a plasmid, it's not clear to me that you're really stepping over the threshold the way they've articulated it, even though I think that they in no way intended to say that recombinant DNAs, ones that come from two different organisms, are not patent
Isn't
eligible.
that mostly an obviousness argument rather than a patent eligibility argument?
Yes, and I think that's exactly what they've done, is I think that they have muddled the two together.
So as patent lawyers, you would have liked a much brighter line decision.
Possibly, it depends on what the bright line was.
You would have liked the decision you were asking for, but if you had to lose it, you wanted a brighter line
It's a
decision.
complicated one because patent attorneys will be having full employment for some
Yeah,
time
it really
to
is
come.
going to be full employment. Because look, it's substantially different. So if I add a little methyl group to a molecule in a place that doesn't matter, then maybe that's not substantially different. But your examples here, the little methyl group makes a big difference. So it makes a big difference to what? Function, I guess. Of course, it's kind of funny. I agree with you. This is a little bit messy because if we're talking about a patent on a thing, a composition of matter, an arrangement of atoms held together, whether or not some little change to that composition of matter makes it substantially different sort of depends on what you were thinking of doing with the composition of matter.
Well, not only that, but the notion that the chemistry of DNA doesn't make any difference strikes me as sort of preposterous, actually, because the whole chemical structure of DNA is what allows many of the most important things about it. It's not just information content. It is information content that happens to have a lot of important different functions within a cell.
Yeah, and of course, if it's just information content, you would say, well, RNA and DNA have pretty similar information content. And then the cDNAs might actually have to, you see, we're not actually ending up disagreeing as much as we should be for a good argument here, because I think while we each wanted different results, I think each of us would have liked really clear result here. And it is kind of messy in the middle, but I'm going to go back to fundamentally, the Supreme Court has been pushing us more and more to clarity about what has to be in the public domain. This is a whole set of issues, I think, that also come up in copyright law and elsewhere, that the ability to mix and match some set of primitives and combine them really gives kind of clear protection to people who want to start with this raw material. And that, I think, is really important, because when I think about diagnostics, so many companies were avoiding going into diagnostics because there was a claim here on this gene and that gene, and on lung cancer genes, mutations in lung cancer, mutations in EGFR and this and that. So because there was this balkanized world, people didn't go into it. Now we know that it's pretty clear. Human genome, open territory. Natural products, open territory. So I'm not unhappy with the result, although I do think it will create a lot of good work for you guys. So.
Yeah,
This is a debate that will go on. And actually, you two were friends of the court. You're friends of truth, which is a welcome injection in a debate that might have gotten far away from it. And in that spirit, I want to ask our science expert here, do you want to make a comment here? I heard one critique of the opinion that there are 3 factual errors in the first paragraph.
Actually, that was the first that wasn't the first paragraph of the opinion. That was the introduction before the official opinion.
The
So,
syllabus, yeah.
I just want to make one comment. I actually don't agree that the decision further muddied the waters here. So I do agree that the court did not adopt Eric's bright line test. I don't know why they didn't adopt it. It's possible that they felt uncomfortable doing that because of Claire's argument that Myriad didn't just, create random fragments. It actually decided where the gene stopped and started. That's an argument Myriad made over and over again, that there was some act of invention out of the fact that they actually figured out where the BRCA gene stopped and started. So it's possible that that Myriad's claim that actually isolated a particular sequence or a particular segment is different from the notion that these various fragments are circulating randomly in the body. So regardless, it would have been nice if it was a bright line argument, but I actually think what they said was completely consistent with what they've said all along. Now, you might say that's fairly muddy, but in Diamond versus Chakrabarty, that Glenn talked about, the court found the primary reason why the court found that Chakrabarty's genetically engineered bacterium was patent eligible is because it found that it was markedly different from the bacteria that existed in nature before it was altered. So that markedly different standard, I think the court did its best to apply that here and found that isolated DNA, the chemical changes, the very minor chemical changes that occur when you actually isolate the DNA from the body and from the chromosome are incidental to the process of isolation, and they do not result in anything that's markedly different. And there was no intention on the part of Myriad in breaking those bonds and isolating that DNA. It was just a part of the process of isolation. Therefore, the isolated DNA is not markedly different from the DNA in the body. So I actually don't think anything's more muddy here. I actually think it's actually quite
As muddy as it was before.
Right. It hasn't made things worse, put it that way.
So we've preserved the mud, and we're going to turn to clarity now with the help of Professor Rowan, who's an expert not only in patent law, but also in the biotech industry. And as he offers comments and critique, I want the whole panel to think about the question I'm going to ask next, which is, should this kind of question come to judges who don't know the science? But let's turn to Glenn. Professor Rowan.
Thanks. I'm not going to offer any clarity at all. But I can talk about this stuff. And actually, I should probably start by just picking up where I think Claire and Eric's conversation was towards the end, and using it to start where Glenn actually started. So Learned Hand, in his 1911 decision, Learned Hand was a very good judge. He's presented with the case. And by the way, he actually talked about that very question you asked, because in that opinion he said, I can't understand a system where I'm asked to decide these things. I'm not a chemist, I don't know what's going on. Why am I a judge? Why is this being put before me? But he had decided anyway. And he issues this decision and he says, well, how do I know that two things are different? I don't want to deal with fancy philosophical questions. I don't know. How do I know they're different? They have very different functions. They have very different utilities to society. If what an inventor has done, whatever it is they change, if they change something and the result of that change is the public now has something that's very valuable that they didn't have before, that they couldn't have based on what's in nature, then something must be different. That was his metric for whether or not something's different. And that was actually the metric that we used for a really long time until this started coming up. In fact, when I was in law school and I took patent law, we covered this particular topic in 20 minutes, maybe less, maybe 10 minutes. It was just, look, here's the rule, and we're done. So what happened in this case was that, and this was just a different framing, is the question is whether we should use the Learned Hand rule. The Learned Hand rule would probably say that you're allowed to patent these genes. You might not be allowed to patent them for a whole bunch of other different reasons. They might be obvious. That might be, a better line to push would probably be enablement, because have you really enabled all the different things that we're going to use these things for? That would be a better line to push. But are they patent eligible? Learned Hand would say, yeah, it's fine, because you know what? We can run diagnostics now, and before we isolated these things, we couldn't do anything with them. They were just hidden in the body somewhere. We didn't have any way of taking value out of these things and, saving lives, doing great stuff. So Learn Hand would say, yeah, it's patentable, it's fine. There's another way of looking at it, which is to say, no, it's not patentable because it's not new. And this way of looking at it doesn't look at what the function is, what value it's given to us. It looks at the essence of the structure and says, well, look, the essence of this structure is it's the same because what's functionally going on in the DNA, that part stays the same in this other place. And those are the different contrasting models that we have for deciding what the right outcome is here. The lower court case, Judge Sweet's decision said, we're going to look at the essence of the structure. And if the essence of the structure of the DNA is the same for what's been patented, for what it is that exists in nature, it's not patentable. It goes to the Federal Circuit. The Federal Circuit says, no, we care about the utility. They go with the Learn Hand test. It goes to the Supreme Court, and we don't know what they did. We know that they said you can't patent this. They just didn't give us any reason at all, which is part of what makes the decision hard to read. And I've read this decision like 8 times. I have no idea what it holds. I mean, I know it holds that you can't patent genes. I just don't know anything beyond that. Which is just sort of interesting. There's another question that I actually think is a little bit more interesting, and that's why are we even asking this? So all of this is framed around this question of whether this is new, whether this exists in nature. My instinct is who cares? And this actually comes from, or I use an example, I use a case to make this point. There's a famous case, it's called In Re Seaborg. It involved a patent on an element, americium, which is actually a man-made element. It was one of the early ones in the periodic table that falls in the man-made range, and because it's man-made, doesn't exist in nature, it's patentable. So we now know, so this was patented in the mid or late 50s, I think. We now know that when a star goes supernova, it probably creates some of this stuff. In fact, it almost certainly creates some of these elements. Now, the half-life isn't going to last long, but so it does in fact exist in nature. And so while this would have been patentable in the 50s, apparently under the Supreme Court's rule, it's not patentable now. And the question is, how on earth can that be relevant?
So it's not on Earth, it's in the stars.
Right, how on earth are the stars, right. Yeah, so, so do we have like an intergalactic limitation on what counts in nature? What's the rule here? Why are we even asking these questions? So when we want to know whether something's patentable, we want to know, well, do we need a patent for the public to get it? Do we need a patent for beneficial incentive effects? And we also want to know whether or not when we grant a patent, are we going to end up stifling subsequent innovation by giving someone control over too much? Those are the 2 big questions we want to ask. Underlying all of this analysis is the assumption that whether or not something exists in nature is relevant to that. And it probably was 100 years ago. 100 years ago, when we talked about nature, what we meant was a cup of water or a plant you dig up out of the ground or something like that. You could tell a story where that's not the kind of stuff where we need incentives for, and it's the building blocks. But nature has changed on us. Nature used to be really simple. Now nature is really, really big and really, really small. And so what that means is that when we say you can't patent something that exists in nature, and we're talking about something you need, like an electron microscope to get a sense of, or something that we need to, we use using, crazy telescopes so we can, infrared telescopes so we can see what's going on across the galaxy. Why are we asking any of this? Why does it matter? And I actually think that and the brief that Glenn and Eric submitted was great, was amazing, but if you dig down and sort of look at it and say, well, okay, maybe DNA is patentable, but if it turns out that when DNA sort of corrodes in cells and it breaks off into fragments, then, well, no, it's not patentable anymore. There are all sorts of reasons why we might not want to grant patents on DNA, but is that one of them? And if this is the rule that we're using right now to decide whether stuff's patentable, so regardless of whether you think DNA should be patentable or not, the rule that we're getting here is not a good rule. Because it's never good when we start enforcing rules that have nothing to do with what we care about. It may work really well in one particular case, but it's not going to work well when we've got a drug that we want and it turns out, that we didn't know it at the time, but it turns out it's floating around in some leaf plant, in some cell in some leaf somewhere, and it gets struck down on that basis. Or when it turns out that particular compound gets created in a supernova. So anyway, that's my take on what's going on here. And of course, there's also very interesting questions about the diagnostics industry and what the fallout is here, which we can leave for Q&A or other sorts of things.
I think everyone should have a crack at both Ben's question and mine. So another way to put Ben's question is, law comes up with categories, whether they're muddy or clear, that are not just because they're about some abstract truth. They're because they're supposed to help human beings do something in the world. And have we forgotten that in the emphasis on occur in nature, not occur on nature here? Should the whole patent inquiry or patentability inquiry be rejiggered so that it's much more aligned with the questions about incentive or how hard it is to get something? So I think that's a pretty profound question, and it's very, though, then related to mine, which is that something that judges should answer? Is that something instead that legislators should answer, or something that scientists should answer? Should we have a science court, which was discussed certainly in the 1980s? This is a problem I just want to underscore that's not just true in biology and biotech. I mean, the software industry would have a lot to say about these issues too. So who wants to take a crack at these questions?
So
Glenn.
if I could take a first crack, and I think the answers are interrelated as the questions were. So one thing that's refreshing about Ben Rowan's scholarship is most of patent law and patent law discourse is incredibly formalistic, right? It is about the application of formal rules in a way that again, there is sometimes this faux minimalism to Congress that is basically meant to buttress whatever you're going to do. What I love about Ben's scholarship is that it takes the bull by the horns and say, patent is innovation policy, and we have to think about innovation. Now, if you want someone to think about innovation and what's good for innovation, it's extremely clear to me that the courts are very bad at doing this. Just their ability to get expert opinions, their ability to sort through the opinions they get is pretty bad. And their ability to do law articulation, especially in patent law, is terrible in part because of the transsubstantive nature of these rules, especially patentable subject matter. So I think that's pretty bad. Now, the next question, though, is this the best of all the worst possible systems or not? What would it look like to have a legislature that was deeply ingrained in these decisions and making these decisions? One problem here has to do with the role of certainty and the property interest here, and the fear of changing politics and changing appointments to an agency that was tasked with doing it. Do I think that concern is big enough to make me think that that would be worse for the biotechnology industry than having a court being blunt about it, but at least being fixed in some way? I'm not sure. I mean, if FDA is your model, right, one way is to say, I mean, FDA is interesting because we have a whole system.
Drug Administration.
Sorry, Food and Drug Administration. We have a whole system of market exclusivity that's separate from patentability, that sits on top of it, right? And it's reticulated in very complicated ways that if you're interested in, take a course with Ben Rowan, you'll learn much more about it, right? But you might ask, you know, although FDA is theoretically politically changeable with the winds, as agencies go, it's one of the most trusted. And I think most people would say it's one of the most stable over time. We get hiccups now and again, like the Plan B case and stuff like that. But for the most part, it is a pretty good agency. Would an innovation agency that did the same thing for patent law be as stable, offer as much certainty, or would it be rent-seeking and controlled by lobbyists? I just don't know the answer to that question. But to me, that's how I would frame the answer to your questions.
Eric.
So I think this fuss over products of nature is pretty fundamental because I think it is at the heart of incentives here and innovation. You can't invent around a product of nature. I can't invent around looking at your breast cancer gene. It's the only thing I can look at. You can make 32 different kinds of drugs, so don't worry about, you know, protecting me on this drug. You know, give me a patent on this drug because you can invent around it and make other drugs. But the breast cancer gene, a piece of nature, or a natural law, E equals MC squared, or some minor natural law like in Prometheus, there's no way to invent around it, and I think the Supreme Court fundamentally has got that right. I think they've looked at it and they've said, now we're not getting into fine structure innovation policy, but the most fundamental thing is if you can't invent around something because it is so fundamental, so at the heart of something, so much a natural product rather than some man-made thing where you could make alternatives, that's where we draw the line. Now you can always say, well, in some star somewhere there's this element transiently, And you can always come up that I don't think we should worry about those cases. I think that's not what the court's really saying. I think when it says product of nature, law of nature, I think it's saying the raw material with which we must all work because we can't invent around it. When you grant monopolies on things that are impossible to invent around, you necessarily can't be encouraging innovation because there is no innovation around that. So should we have courts do this, or science agencies or science courts or whatever? I gotta say, there's something to be said for courts doing this, because the experts get themselves wrapped up in the details. Courts, at least at their best, step back sometimes and say, the result is just plain wrong. We are going to create some fictions around this to help us fix that. And if you had to be an expert, and I think the Federal Circuit is such a patent expert that they're all tying themselves into knots, making up these. The Supreme Court, I think, approached this and said, this result is so crazy, this can't stand, and worked backward from that, in my opinion.
I'm going to ask
Not so
the rest of the panel for comments on this, and in a minute, open it up to everyone else for comments and questions. I'll say, to underscore what Dr. Lander just said, my old boss, Judge David Bazelon, actually came out the same way you did, but because he was very aware how little he understood the science he was being asked to adjudicate, but he also said, we're a democracy. And if you can't explain it to ordinary people, we're in trouble. Because otherwise the people won't be able to govern, people won't be able to set the norms. And that was a pretty good embrace of the humility of ignorance, but, you know, educate us scientists, basically, is what he was saying. So Claire, do you want to comment?
Yeah, sure. In terms of institutional competence, I think that actually judges are good at deciding these kinds of questions, and many of the judges, including those on the now much maligned Federal Circuit, have very good science advisors and other people who can help them. I was a little troubled by the fact that the Supreme Court, which has to be the best resourced court in the world, did not seem to avail itself of whatever advantages it might have gotten in trying to get a little technical help. And I almost felt that they came to the case with the attitude of, you know, we don't really need to understand the technical details. And I have to say, I do disagree with that.
What could they have done? They couldn't appoint a master. What could they have done? They have a pretty good library, but beyond that.
Well, I think it's hard to know. I mean, in patent cases in the district courts, they do appoint people, and the Federal Circuit actually hires technical clerks. Given the fact that the Supreme Court is, shall we say, harshing on the Federal Circuit these days, it seems to me that they should probably be hiring some technically trained clerks to help them understand the science, because I really do think that chocolate chip analogies are not appropriate here.
Does everyone know the chocolate chip analogy? Maybe you could tell everyone how that came up.
Yes, well, there were a number of, shall we say, homely analogies that became the subject of conversation during the oral argument. One, which counsel for Myriad suggested, was actually about a baseball bat. We also had discussions about chocolate chip cookies, and there were a few others that I've blotted out of my mind now. But those are really pretty different, actually, from DNA. And
That's from the Amazon.
so I was troubled by that. At the same time, I do think that judges are not competent to deal with what I think underlies a lot of the passion about this case. I think the reason that you all are here is not necessarily to talk about the distinction between full-length DNAs and cDNAs, or even Section 101 of the Patent Act, which I bet a bunch of you had never heard of before today. I think that there's a lot of moral interest in the question of the extent to which people own their bodies, they own their genetic material. There's a lot of interest around questions like Henrietta Lacks, whose DNA was used to make a cell line that is now used in laboratories all over the world. And these moral questions of the extent to which we have property interests or something even more fundamental in our own bodies, I think those are not really questions that are appropriate for the Supreme Court or any other court to adjudicate through this one particular very technical section of the Patent Act that has had so much sort of judicial accretion and has such a history to it. I think that that's an inappropriate vehicle for what a lot of people were actually trying to achieve in this litigation. So in Europe, they have science courts. It's not clear to me that their results are any better. I'm fine with the judges, but I think we need to understand that they cannot really address the moral questions that are important to so many people in the context of the legal questions that are presented to them. So
we're going to turn to questions, but can I read just the Patent Act, Section 101, because it's so interesting. It says, in relevant part, whoever invents or discovers any new and useful composition of matter or any new and useful improvement thereof may obtain a patent therefor. That's
and
it.
discovery.
Yeah, oh, sorry, and discovery. But,
And
but the thing
discovery.
is,
It doesn't have
the
to be
entire
something that didn't
thing-
exist before.
Yeah, but the point is, it's just that. All of this debate is reading meaning into what could be read as a trivial preamble to a law and does not appear to be excluding anything, but more like a constitutional provision than a piece of legislation. The court has gone over and over this thing and found within that sentence exclusions. And to me, as a scientist, it's not obvious how a statement that says whoever does this can get a patent intends exclusions. I'm all in favor of those, but
Eric, obviously you need 3 years of law school in order to
to
understand
see
that
why
question.
that means that there are exclusions. Anyway,
Well, when the source of the law is very limited, then you count on the judges to build their own interpretations, and between any 2 points in a statute like that, you could have an infinite number
yeah,
of points.
clearly.
Don't forget the Constitution only says due process of law. That's all. And we get like half of the civil procedure syllabus from those words.
So I wonder, Ben, do you want to comment, and Tanya, do you want to comment? Tanya, Ben first?
I mean, just quickly on the stat, all of these rules that we have right here out of 101, they're very old, or they come from, and basically they predate all the rules we currently have. So they predate the novelty requirement, they predate the obviousness requirement, they predate the enablement rules. What we've got right now, these sort of very vague, no one knows what 101 means. They essentially, they're the very early signs of the courts trying to work out what the standards of patentability should be. After a while, Congress started actually writing in what the rules are, and so that's what we do most stuff. We do most things that are novelty and obviousness and enablement and utility. But these old standards from these 1800 cases from the Supreme Court are kind of floating around. And once every 20, 30 years, they rear their head and they start doing weird things, and we don't know what they're doing because we don't know what purpose they serve anymore. They used to serve a clear purpose. We understood they were basically trying to get at obviousness. They were trying to get it, But now we've got other specific rules for that, and so it's very unclear what's going on with them. I will just say one thing quickly about the
It's
judge.
like the appendix, it's something that's just left over.
Yeah, right. Yeah. I mean, and it could be, and they could be doing something really interesting and really valuable. But because we don't know what they're doing, they don't have an assigned purpose, and just the way they're written is super vague. It's really unclear. It's actually very frustrating to teach. Every other area I know, it's a rule, it's a standard. I just have no idea what's going on in 101. But on the judge question, I think I just say this. When courts are at their best here, they come up with a rule or a standard, whatever it is, that makes sense. And they may get all the facts wrong, and so they may get the wrong outcome in the case, but we can correct that later on if they gave us the right rule. Because, we'll basically, in other cases, we'll narrow it, we'll as the right facts come up, we can sort of fix it. This case did not do that. What this case did was it gave us kind of a rule, but no logic underlying it at all. We don't know why it was doing what it's doing. And a rule, overarching rule that we don't understand why it's doing the thing it's doing, which is consistent with the Supreme Court's 101 jurisprudence going back, at least 50 years now. So it's sort of frustrating to figure out what's happening here. And I get nervous. People, sometimes they'll read these opinions and you can't see why the court did what they did, but we'll sort of say, well, they must have known what they were doing and they must have known the right thing to do here. That's not, maybe that is what will happen as these rules get applied, but I kind of doubt it. That's not.
Tanya.
So on the product of nature doctrine, I think I would largely agree with what Eric said, which is that it's really essential. Just because it's old doesn't mean that we should do away with it. The product of nature doctrine, the way I see it, is that it really helps to ensure that the patent, that the whole process of issuing patents is doing what it's supposed to be doing, that the patent system is actually functioning in the way it's supposed to. The whole idea behind a patent is that we're going to give you a limited monopoly over your invention so long in return for you disclosing that to the public. So that people can use it so that follow-on innovation occurs. The problem when you patent a law of nature, a product of nature, or an abstract idea is that follow-on innovation cannot occur because you're tying up this basic thing that no one, as Eric said, no one can actually invent around it. If you have a patent on a gene, what Myriad patented was not just one particular gene. You know, everybody in this room probably has a slightly different BRCA gene. But their patent was written so that they actually had a patent on every single person's gene in its isolated state. Everyone's gene, even though they haven't looked at your gene and your gene and your gene and your gene. The way the patent was written, it was the DNA encoding for that gene, regardless of what the spelling of that DNA actually was, no matter in what mutated form. They actually patented any mutation found in the future, even mutations they hadn't found yet, because they actually have the whole gene. So somebody else can go and do research and find a mutation, but Myriad then owns that as well. That can't be right. So we need the product of nature doctrine. We need it because it helps to ensure that the patent system is operating, at least in some ways, in the public's interest, and actually ensuring that follow-on innovation occurs. There's actually some literature to support that gene patents have actually, you know, even while gene patent holders haven't generally prevented researchers from doing research on genes, that the patents end up having a chilling impact. And there have been a couple of studies, one coming out of MIT, that shows that, you know, follow-on innovation is actually curtailed when genes are patented as opposed to genes that are just published. So I think we need the product of nature doctrine. On the question of science in the courts, again, I think I agree with Eric and what some others have said, which is that the courts are what we have, and the courts are generally good at doing these things. And I think we have to be really careful about buying into the notion that this is too complicated. The scientific questions in this case were really not that complicated. And Eric's brief was brilliant in that it actually really helped to explain that this is really not a very complicated question scientifically. And people with, you know, very smart judges, for sure, and justices at the Supreme Court certainly are in a position to understand the science and grapple with the science. I think what we need are more people like Eric who are engaging in these matters. I think we need more people who are trained in truly interdisciplinary fashions, who are participating in these processes. You know, one thing I alluded to a number of things that helped shape this case and the outcome of this case, and one of them was that Judge Sweet, who decided the decision in the district court, happened to have a clerking for him at that time who had a PhD in molecular biology. I have to say the chances of that are probably 1 in 2 zillion, and you know, the result was a beautifully written opinion, whether you agreed with it or not. It was scientifically quite accurate. And you know, so, and really helped to set the stage for the whole case, and people can criticize whether they got something right or wrong or understood something right, but I think by and large, they basically got it. I also just want to say one more thing, which is, I think we should be careful about criticizing the analogies that the justices threw out. Some of them were a little bit off pace, I will agree, but this is how people understand science. Science is intuitive. It should be understood through analogies. There's nothing wrong with that. It's good to have your analogies well thought through. And lawyers are really good at thinking about analogies and understanding things that way. And I think there's nothing wrong with actually understanding science in that way. And I think they got a couple of the analogies actually right on. I think Myriad was wrong about the baseball bat. And the baseball bat analogy was basically like, you know, it's like carving a baseball bat out of a tree. You know, nobody would say that you couldn't, that's not an invention. But the difference of the baseball bat and the tree is that trees don't have pre-carved baseball bats inside of them, like genes are to a chromosome or to the whole DNA. Anyway, so I actually thought that some of the analogies were actually just fine. I think that we have to be really careful about assuming that people can't understand science, and we need to turn it around and bring science to people
Dean,
and to
as you answer
judges.
questions, let me just mention that at 5:30, when this breaks, we'll have a reception for the open house at the Petrie-Flom Center. So we'll have an opportunity to talk more to everybody here if you don't get your question in.
That's wonderful. And Tanya just made a wonderful advertisement for the Petrie-Flom Center, which is devoted to the kind of interdisciplinary debate and education that you called for. And actually, I'm hoping that it won't be so unusual to have clerks with PhDs in biochemistry or other fields. And the increasing presence in law schools of people with serious STEM backgrounds is just absolutely essential. This is not going to be the only case raising these questions. The same term, the court had another case, the Monsanto case, dealing with self-replicating seeds. And we're going to see an escalating number of cases asking questions. And let's be clear, in that case, the court upheld the patent. So I do want to ask for questions, and would you please do two things? One, identify yourself and press your microphone, the green button, and then when you're done, unpress it. So please. Is it, yes.
Sorry. Oh, I see. Okay.
Okay, and say who you are.
So I'm Morrison Imolinsky. I'm a physician and a genomicist. I know very little about, or almost nothing about patent law. My sense about this case was that, I was against the Myriad having a patent, but I do think that, let's say the discoverer of Taxol, whoever purified and isolated Taxol and found from the yew tree and found that it had anti-cancer activity should have a patent. I believe, let's say Genentech should have a patent for recombinant insulin. But I guess so the outcome of the case seems reasonable, but the argument with regards to protecting cDNA seems a little bit flimsy. I mean, if you use a little bit of scientific imagination, you could say, well, cDNA are created by biotechnologists using RT-PCR, and that the enzyme reverse transcriptase, which exists in viruses, exists in retrotransposons, and we know that cDNA are created spontaneously at some frequency and occasionally deposited in the genome as fossils called pseudogenes. So, eventually I could come up with an argument against.
So the court, I'm going to jump in,
right.
figuring I might be the best to address that question and translate just a little bit. The court did allow patents on this thing called cDNA. So DNA is copied into the equivalent of little yellow sticky notes that get sent off to the factory to get turned into proteins. And before the little yellow sticky notes get turned into proteins following the instructions, little bits are clipped out of the instructions and they're glued together. That's called gene splicing. And they get turned, the little yellow sticky notes are called RNA. So DNA gets copied into RNA, which is the order to the factory, and the RNA gets spliced up. And the point in the Supreme Court's decision was, if you turn that RNA, after it's been spliced up and bits thrown away, back into DNA, well, there isn't any DNA in the body that has exactly that sequence. And that's what the court said, and I think the court's right. It sounds to you, now you're saying, well, but it's hypothetically possible that the body might turn that RNA back into DNA. Footnote 8 addresses that. The court actually addresses that in footnote 8 and says there actually isn't any particular instance of it being turned back into DNA in the body, and that's highly hypothetical. And I think that gets to Ben's point about stars and all that. The court says in footnote 8, don't turn yourself into a pretzel about hypotheticals. And that's really what they're saying.
But just to finish the point. So I'm wondering if, all right, so we could have a scientific debate about whether, how likely that could be, but I'm wondering if the rationale there is a little bit also disingenuous, because really we know that the ingenuity that comes down to creating a recombinant drug isn't really that RT-PCR step at the end. We know that the ingenuity is everything that came before then. In the same way, I would imagine that technically it's more difficult in many cases to purify a compound from one of many thousands of compounds from a tree bark than it is to synthesize a particular cDNA these days, right? So,
yeah, but Marcin, he's, by the way, a lung cancer expert. The point is that the patent law has other ways to deal with stuff that's hard or obvious or non-obvious. Those are other sections. This all is simply about one little section of the law, which is about, is it in nature?
Yeah, I'm going to disagree.
cDNA is not in nature.
Yeah, so I think the patent law claims. So I think you're asking exactly the right question, which is, okay, can you patent cDNA under this rule? Yeah, you can. Does that make sense? Should you be able to patent cDNA? Is it really hard to do that? Is that the place where we need to provide incentives? You know, we don't need to provide incentives for the DNA, but we need to provide incentives for the cDNA. Or, you know, I mean, and does this rule make any sense? Along the same lines, well, okay, so you can't patent. And by the way, this is true. So let's say there's something in grapefruit that actually is interacting with when you take drugs. It's making them much more potent or decreasing their potency, and you want to figure out what that, and by the way, there is. You want to figure out what that is. And so you want to extract. You go, figuring out what that compound is in the grapefruit turns out to be hard because there's like lots and lots of stuff in grapefruit, and you've got to figure out first you've got to figure out what's going on there, and you've got to find the thing that's actually doing it. That's actually very difficult, not to mention the fact that once you actually find that thing and you need to turn it into a drug or something like that, that takes a huge investment. You know, but so do we really want to sort of say, oh, well, you can't do that there? Like, why are we asking this question? So it's all framed around this idea of, well, if it's in nature and you allow it to be patented, then it's a building block and can be used for lots of different stuff. Is that true? I mean, it seems like maybe it's true for DNA. Like, I mean, you could make that argument. But is it true for that little compound in grapefruit?
All right,
It doesn't sound like
we're
it.
going to let Tanya say something, then there are like many more questions,
let's
plus
take
I have some from the overflow room. So everyone try to be succinct.
I think you're referring to pseudogenes, right, that actually do exist, and we did make that argument. I think it is useful to say, to view this the way that Eric talked about it actually in his brief, where he said that you should really see this sort of on a spectrum. You've got sort of isolated you've got genomic DNA over here, then you've got cDNA, and then you've got recombinant DNA, and everybody can agree that recombinant DNA is patent eligible. It is definitely not a product of nature. And I think everybody should be able to agree that genomic DNA is a product of nature. And then you've got this cDNA, which maybe is somewhere in between. I think that we felt that it was closer, just as you're arguing, to the genomic DNA, and others felt that it was closer to recombinant DNA. I think in the end, though, it's okay from a practical standpoint, the way the court came out. I think that, you know, as I alluded to earlier, I think there are ways to invent around it. But I think I agree with you that that I would have preferred that the court went our way on that issue.
Dean, I'm told we can go a few extra minutes if we need to.
Excellent. Excellent. Let me just say that there are two questions from the overflow room that are both right on point. They're both about cDNA. One is a concern by a PhD student that this person makes cDNA all the time. Should I be concerned that I'm inadvertently infringing on someone's cDNA patent? And another indicates that Myriad over the summer actually started offering BRCA tests in the wake of the decision, and some, including Senator Leahy, have called on the government to exercise its own rights and to ensure that the patents on cDNA don't stand in the way of genomic DNA. So there's questions now that this case has generated about what this line is, and are people in danger of infringement about cDNA.
Dean, can I say something quick on that?
Yes.
Which is the following. Remember, although this is imbued with a whole constitutional flavor, this is just a statute, right? If you don't like where the line is drawn, Congress can change it at any time. So, you know, call your...
It's so easy to pass laws.
Wow, yeah. But, you know, this is just to say that,
Written
you
in
know...
stone. It's not written in
It's
stone.
stone.
Yeah, not written in stone. All right, please identify yourself and ask your question. Oh, well, I think we're going to go to some more questions. Yeah.
Hi, Nicholson Price at the Petrie-Flom Center. I'm just wondering a little bit of a very practical follow-up, which is that Ms. Simoncelli mentioned that, you know, some companies started offering tests the next day. I think what's the next step is that Myriad also sued them the next day. And Myriad's line was, look, before the decision, we had 140 patents with 250 claims covering these genes. The day after the decision came down, we have 140 patents with 245 claims covering these genes. So does this actually make any practical difference in terms of diagnostic tests, or are we all just theorizing?
Good question. Who'd like to answer that one? Claire?
I think that so there's going to be a lot of litigation about Myriad's tests, and it's true that they have a large number of claims, including ones to long cDNAs. So I think that one of the sort of scientific confusions here is that some of their claims, which might be harder to defend, go to sequences that are very, very short, while others actually go to full-length genes. The full-length gene claims, I think, are going to be more difficult for people to defend against, and certainly it's impossible to handicap that litigation now, I think. But, you know, I agree. I think that fundamentally, you know, we were all waiting for this great decision from on high, but when the distinction came down that it was going to be genomic DNA versus cDNA, and there was going to be a big line drawn there, Eric likes that, but it's not clear to me that most of the people who were investing this decision with a lot of moral significance really achieved much.
No. Look, if you want to do diagnostics, cDNA is utterly irrelevant. Let's just wipe away this whole confusion. If I want to diagnose your genome, there are no cDNA claims that affect that. cDNA may affect whether I can make a recombinant protein of BRCA1 by putting it in a vector and doing complicated things. If I want to get your DNA out of your blood and read it, the cDNA claim is utterly meaningless and irrelevant.
There's no cDNA in a person.
There is, when I'm reading your genome and finding out you have a mutation, I ain't looking at cDNA, I'm looking at genomic DNA. It's really simple. Myriad, if it has any remaining claims, and I don't see how it has any remaining, it could defend using a cDNA to make a protein, et cetera. That's not diagnostics.
Well,
they are
many of their
screwed on
claims that they're-
diagnostics.
Many of the claims that they're asserting are method claims.
Oh, I think that
Method claims are a different thing, but the cDNA is not the issue.
Okay, well, I see 7 hands. We're going to start over here and
Hi.
say who you are.
Just push? Okay. I'm Jessica Silby. I'm a professor of law at Suffolk Law School. So my question goes to what Professor Rowan asked before about, so why do we care about the law of nature doctrine? And it answers maybe, or tries to answer Dean Minnow's question about courts, which is, I always thought that the law of nature doctrine was a statement of value. That is, where innovation policy comes secondary to the public domain. And that it's just that statement. And so the 101 is preambulatory, just like the preamble to the Constitution is preambulatory, and it sets a baseline for the kind of things we might want to protect and things we won't want to protect for investment value. And I'd like to hear whether that's right, that innovation policy does come secondary to building a public domain. And so on that question, I'd like to know also, because I used to litigate patents with Claire, I should say. But I don't know the answer to this anymore, which is, why should we care whether it's a 101 bar or a novelty or obviousness bar from the perspective of industry and incenting innovation?
Great. So, Ben, I think I call on you for this.
All right, well, so, the last question first. We care about what the rule is because it'll have different effects in different cases, right? So if we want to get rid of gene patents, we don't want to necessarily use a really strict natural products rule, because the natural products rule will apply to lots of stuff that exists in nature that aren't genes. So that would be basically it's a question of how you do it affects more than just the individual case. It's going to affect the other cases, and industry's going to have something to say about that. Of course, the people who just want gene patents don't care either way. They may, if they lose, they lose. As to what 101 means, I think the way you describe it is actually the way commentators view it, and I think it's the way both within the legal profession, not lawyers, but sort of law professors, but also the way people outside of the legal profession view it. It's just a statement of value. As you look at a particular patent, you think, should this be patent? And this is actually the way it seems to me the Supreme Court does it too. You look at, should this be patentable? If I feel like this should not be patentable, I'm going to use 101 to get rid of it. I don't like that because I don't understand what they're doing. And I don't understand the logic behind what they're doing, and it looks to me like there isn't a logic behind what they're doing. If there is a logic, I just want to, what in fact is the logic? Because if we're going to construct a rule out of that, it would be nice to know what it is. But having just sort of a system where the courts are going to look at something on a case-by-case basis, or the Supreme Court is going to look at something on a case-by-case basis and say, well, should this be patentable? Shouldn't this be patentable? Which I think is an accurate description of what's going on with 101 right now, is not the way the patent system can operate. Because we need a set of rules or standards, whatever it is, that the PTO can use to decide whether, when they get the 500,000 patent applications each year, whether they're to grant or not apply, to grant or deny.
So you're saying it actually does affect whether innovation occurs or not?
The patent system?
The
interpretation of 101.
It could. It could. It might not. But so for example, not this guy. So this case. I don't have views. So I have views. I don't know what the right answer is with gene patents, whether they should be patentable or not. Drugs probably need patent protection. The opinion that came before this, Mayo versus Prometheus, that will almost certainly have effects on innovation. That was a very profound, very important decision. And it was 101, and I don't know what that opinion said either.
Glenn.
So it's always a bad idea for me to say anything about patent law with Ben sitting here, so he'll correct me if I get it wrong. But my understanding, there was a period of time in American patent history where we had like moral rights or moral patent exceptions, and there were questions about like a method to have an abortion, for example, whether that could be patented or not. And certainly there are countries that do that, right? So to me, I think there's a question here about design. Do you want to have a patent system that is very consequentialist, focused on innovation, or do you want to have a system that starts with a kind of deontological principle and move forward? And to me, that's a values question, a perfectly good question and discussion. But to me, 101 is susceptible to either interpretation, and we have to have a values conversation about which one we prefer.
There's a hand over here. Please identify yourself.
Hi, I'm Noam Previs. I'm a chemist at MGH. I have a question for Councilor Lepore and Professor Rowan. If what we're worried about is protecting intellectual property to allow innovation, if we're worried about protecting intellectual property to allow innovation, what would happen if we made the bar on compositional patents much higher, but at the same time sort of relied on use patents more? And is that the right question?
The answer can also explain a use patent.
Okay, so there are many patents that are drawn to a method for doing something. So for example, I had a big case about a particular surgical method involving a novel surgical device one time. The problem with method patents generally is that first of all, in many countries around the world, those things are not patentable. And secondly, enforcing a method claim right now is like climbing Mount Everest, only harder, because there are a whole other series of decisions and opinions of the courts, including the Supreme Court, that have made it so that it is extremely difficult to enforce method claims right now. So, for example, when I talk to people who are interested in enforcing method claims, I do have to tell them that it's very, very hard. And, for example, if the other side has an opinion of counsel suggesting that they don't infringe or that the patents are invalid, that opinion, however flimsy, may be enough to get them out of infringing at all. So the problem is that method of use sounds very nice, and we often try to say, yeah, you know, that is what people should really be looking at here. And the problem is that the rest of the law is standing in the way of that solution.
Okay, next question. Please identify yourself right here.
Shannon Pendergrass from Weimar Genomics. I'm wondering if the Prometheus decision or the Myriad decision affect patents on diagnostic tests based not on the sequence of the gene, but on the expression of the gene. In other words,
I'm wondering if measuring the naturally occurring amount of a natural RNA in the body is somehow patentable subject matter?
well, there are certainly many patents.
So I think the answer is pretty clearly, if you read Myriad, no. It's not patentable subject matter because measuring the DNA wasn't, measuring the RNA ain't either. And there are a lot of patents written to measure the amount of the levels of different RNAs to draw an inference. And I think the combination of Prometheus and Myriad leaves that uncovered by patent.
And I will say of the two that I think if you're worried about what bore fruit, it's going to be Prometheus. As important as Myriad is, I think it's Prometheus that will be the real game changer in the industry.
Can I just add one thing about Prometheus? So part of the problem here is that many of the claims that are at issue in these cases are ones that appear to be almost contemplative in nature, where you measure some particular thing in the body and then you sort of think about it. And the reason that they're written that way is to get around yet another doctrine, which is the doctrine of divided infringement, that until recently, if, for example, one person did the measuring and another person treated a patient as a result of that, then there was no infringer if there were the steps of evaluating and treating in the same claim. So you might think that being able to treat somebody, that would be patentable, but because usually the evaluation is done by somebody at a diagnostic lab and the treatment is done somewhere else by someone else, that made it until fairly recently pretty impossible to enforce claims that were written that way. There's a recent decision that perhaps makes that possible, but as you can see from this discussion, there's a lot of development of patent law that affects industry and innovation and what can actually be done to protect people's innovations that isn't related to the question before the court in Myriad.
Okay, back here, say who you are and. Hold it down.
So, Variant, genetics fellow at Mass General and the Broad Institute. Could you talk a little bit, this was mentioned in the beginning, but could you talk a little bit about whether there's a fundamental difference between naturally occurring products, things such as a gene in the genome, and a naturally occurring pharmacological compound extracted from nature, for example, a growth factor or something like this?
The question is whether there's a way to distinguish the naturally occurring gene versus the naturally occurring compound, right?
So can I ask the lawyers on the panel? So gene, not patentable. Insulin, human insulin purified from the body, or Taxol from the yew tree, or some magical compound from a sponge in the South Seas. Under Myriad, patentable or non-patentable?
I think we don't know. What was so this was
You
so
can trust the lawyer to give that answer.
The opinion goes out of its way to only talk about DNA and to never actually have a full sentence together that both says DNA isn't patentable and gives the reason why in the same sentence. And so they just get like platitude, DNA doesn't work, platitude, DNA doesn't work. And what that means is that we actually, this case could be confined to DNA, which is actually what the district court had done. The district court in this case said it only applies to DNA. And had a theory for why that would be true. That was clearly what the ACLU was aiming for, I think, because I don't think the ACLU had an objective of going after like natural stuff in general. It was DNA, right?
In fact, we distinguished some of those purified compounds from patents on DNA, and I think that they can be distinguished. Purified Taxol, purified adrenaline, these things were purified to have a therapeutic effect. It's very different from a gene. You isolate a gene, you don't purify the gene, like it's no different. The function of the gene is exactly the same in its isolated state. You can in fact take that gene and you can actually stick it back into a cell and it'll continue to function the way it does in the body. So I think that is the difference.
But I will say this, that if you were an investor looking to fund a biotech company that was today purifying it before Myriad versus after, you would be much less likely to invest in that, because I do think the uncertainty is here. I'm actually not sure that I agree with Tanya's reading of the opinion. It may not have been what ACLU...
Oh, I'm not reading the opinion. I'm just saying I think there's a way to distinguish
the two.
Right.
What ACLU was going for. But I think the end result may actually... I think there's still wiggle room, but I think the end result is after Myriad, you're much less likely to be able to get a patent on that as a probability.
So empirical fact. We invited a couple of patent attorneys over to the Broad about a week ago to ask them in their own practice what's going on. 2 facts worth stating. Diagnostic companies are not getting funded. New diagnostic companies around this test or that test are not getting funded. I think that's fine because I think it's a nutty way to make diagnostic companies around little tests. I think this is about aggregating tests, lines of distribution, but empirically they're not getting funded. Funding for naturally occurring proteins or Taxol and all that, not going to happen. All the lawyers we polled said clearly are not patent eligible anymore, but they also said doesn't matter because it's trivial to take a naturally occurring thing like Taxol and modify it in some way to slightly improve it. So whereas for diagnostics, they thought this is going to wipe out a lot of diagnostics companies, they thought for drugs, it's a nuisance. It's a pimple on the elephant.
So your distinction, Eric, about you can invent around it applies here easily. And also, this does seem to me very relevant to Claire's earlier point about the intuitive moral dimension of the patenting of a human gene as opposed to other objects. But the uncertainty is going to be here. It's going to be uncertain for some time to come. I think that our time has come, speaking of time coming, but I also think this discussion just underscores why it's crucial to have interdisciplinary conversations, why we're so proud that the Petrie-Flom Center is here, why we need lawyers and scientists talking with each other, and why we're so grateful to this particular panel. So please join me in thanking them.